Thanks everyone for joining us this afternoon. My name is Tim Richards. I'm the Technical Services Manager of the Managing General Agents Association, or MGAA, and I'd like to welcome you to our briefing this afternoon. This is being delivered by Clyde & Co on the subject of the risk of AI in employment. Before I introduce you to our presenters, I'd just like to run through a few housekeeping points. First of all, please ensure your microphone and camera are turned off. If you would like to ask a question, feel free to use the chat button at the bottom of your screen. Time allowing, these will be asked and answered at the end of the event. If we run out of time, questions will be answered post-event. This presentation is accredited for CPD points if relevant to your ongoing professional development programme. This briefing is being recorded, and a link to the recording will be issued post-event together with the slides and our feedback survey. Please take the time to complete our survey, which will take no longer than 2 minutes. This allows us to deliver the best possible future events to our membership. So today's briefing is on the subject of the risk of AI in employment from Clyde & Co. So let me introduce you to our presenters, Heidi Watson and Charlie Watson. Heidi is an employment partner at Clyde & Co in London. She provides support to HR and legal teams on the full range of employment issues, from day-to-day employee relations queries through to the most complex projects and reputational disputes. With a particular focus on advising insurers and broking firms, Heidi also advises on non-financial misconduct under FCA regulations and Lloyd's bylaws. She regularly provides HR and manager training on all aspects of employment law and HR practice. Charlie is an employment lawyer and is based at Clyde & Co's London office. He predominantly advises employers in responding to litigious claims in the employment tribunal, including unfair dismissal and discrimination claims. He also regularly advises clients on complying with their obligations under the UK's anti-discrimination laws and has a particular interest in the regulations surrounding the use of artificial intelligence in the employment and human resources sphere. So without further ado, enjoy the briefing everyone, and over to you, Heidi.
Thank you so much, and thanks for having us here today. So my colleague is going to move the slides on for me. So summarising the learning objectives that we're going to cover today. So by the end of this session, you should be able to summarise generally how AI is used in the employment lifecycle, to understand the key discrimination risks, to describe some of those key challenges that employers are facing in managing those risks, and to have a good understanding of the UK policy-related developments which employers would need to know about, and outline the key steps that you can take as an employer, or employers can take, to mitigate these risks. So what we're going to cover today, we'll just talk briefly about what an artificial intelligence system is in very high level terms. We will talk about how AI is increasingly being used in the workplace, what those discrimination risks might be, and the changing regulatory landscape, and then how we are supporting our clients in managing risks in this area. So what is artificial intelligence then? Well, there's actually no one universally recognised definition of AI, and the term is not currently defined in any UK legislation specifically governing employment law. Having said that, AI tools are sort of broadly understood to mean systems and technology which process data in accordance with predetermined instructions to reach conclusions and produce outcomes, and doing so usually more efficiently than a human would be able to. And there's various elements to this, such as algorithms, machine learning, and automated decision making, which contribute to the technology that we broadly refer to with an umbrella term of AI. Now, the key point to remember with AI is that these systems rely on historic data sets to learn from, and they take that data to make their decisions. Charlie's going to come on to talk about this some more, but I pointed out now at the outset that clearly historic data sets are collected by humans, and they contain information about historic human behaviours and norms, which is embedded within the information that underpins AI. And this can create problems for the technology, which is effectively just doing what it's told by humans and based on what can be flawed data sets. And we'll explain a little bit more of that as we go through. Next slide, please. Handing over to Charlie, I think.
Thanks very much, Heidi, and good afternoon, everyone. So I think the first point to really be aware of when we discuss AI in the employment sphere is to know that it's being used by many, many employers, and it's increasingly becoming more and more used by employers in the employment life cycle. So we've included a couple of facts on this slide which shows you that 98% of Fortune 500 employers are using AI software at some stage, part of the hiring process. So like many things, sort of North America is leading the way in this space. And in Europe, it's slightly less. It's around 40% of employers are using artificial intelligence to support their HR functions. So I think it's clear that, particularly in North America, but also Europe, that it's more likely than not that employers over the next sort of 5 years will be using AI, at least in some stage of the employment life cycle. And I think that takes me to the next sort of issue on this slide, which is where are employers using it? And more often than not, we're seeing employers using it at the hiring process, and in particular, at the sort of preliminary hiring process. So there is this AI software, which I'm sure many of you might be familiar with, called CV sifting. And essentially what that software does is that it looks at all the resumes that have been submitted by candidates for a particular job, and the software will scan those resumes for keywords that it likes and keywords that it doesn't like. The words that perhaps it doesn't like, it will then put in the virtual bin, and the words that it does like, it'll put at the top of the virtual pile, and they will then go to sort of the next round of the hiring process. We also see it in other parts of the employment life cycle, in addition to the hiring process. So we see it in sort of mass scale redundancy selections. So we've seen a number of companies in the last couple of years use interview bots to assist the business in deciding which employees should be made redundant. And the way that this technology works is that you will literally have an interview with a robot. The robot will assess the words that you're saying, the intonation of your voice, the speed at which you're speaking, the level of eye contact that you're making with the camera, and then it will give you a score based on how you performed in that interview with a robot. And we also see interview bots as well at the hiring process, in addition to at the sort of end of the employment life cycle. Less frequently, but still occasionally, we'll see some employers use AI in managing employee performance. So that's been particularly a focus in the last couple of years, where more and more workers have been working remotely, and there'll be some employers that use AI to scan the level of productivity of a worker whilst they're working remotely. So that may be the number of emails that they're sending each day. It may be the types of words that they're plugging into a particular email. And on the topic as well of employee performance, we've also seen some employers use it to manage potential employee misconduct. And in that particular space, we see some employers use facial recognition technology to ensure that where a worker is working remotely, that they are in fact the person that's performing their work. So one particular example, and I'll go into this more detail later, we're aware of one company that requires their workers to submit a photo of themselves at the beginning of the day and also at the end of the day. But as I said a few moments ago, most employers are still using human beings to manage an employee sort of performance and employee misconduct. And it's really at the hiring stage and a little bit at the firing stage that we're seeing AI being used. If we could go to the next slide, please. So I think before we talk about some of the issues of AI, I think we all know that human beings are subject to, in some cases, and hopefully not too many cases, overt bias, but also a large level of subconscious bias. And I think that's why when AI sort of came to existence, a lot of HR professionals and employment lawyers were quite excited at the prospect of having technology replace a human being on the basis that it would eliminate all potential biases in making employment decisions. And I think that's a very fair assumption, because I think we as humans like to think that technology sort of corrects all human flaws. Unfortunately, though, and Heidi touched on this a few minutes ago, that it's a big mistake to assume that AI operates free from any form of human bias. And the reason why that is because AI software isn't just born out of nowhere. It's created by a human being. And the human being behind the product is also very likely to be subconscious to some level of biases, and they're likely to reflect those biases when they're programming the algorithm. And I appreciate that I might be slightly speaking out of turn here as an employment lawyer, because I'm not an expert on artificial intelligence, and I certainly can't do that level of coding that a software engineer can do. But from my research, it seems that either the programmer is incorporating their own biases, or is incorporating historic data, as Heidi touched on, and as we'll explain a little bit later, and that historic data favors a particular group and disadvantages other groups. And we'll now go into some examples of this. So there is one company that recently abandoned their CV sifting software, and it's a tech company. And again, I'll name that tech company later, but I won't give it away right now. And essentially, this was a tech company in America, and they decided that they would use CV sifting software to assist them in deciding which candidates who've submitted their resumes should proceed to an actual interview. So what this company did was that it collected all the data over the last 10 years of successful candidates, and it basically inserted and input that data into its CV sifting software. The issue with that approach was that the successful candidates over the last 10 years were largely males. So we're talking sort of, the mid-2000s in a industry, the tech industry, which unfortunately has been dominated by males for far too long. And that was the data that this software was relying upon. So how did this play out in practice? Well, what this particular company found was that the software was actually penalizing applicants with the term women or women's. So one example might be a female candidate might have captain of the women's chess club on their resume, and the software was seeing that and thinking, well, that's not like the historically successful candidates that we've had in the past, so therefore we're putting that resume in the virtual bin. The company also found that the names of 2 women's only universities were also being penalized, because again, when they were looking at the historic data, there were essentially no candidates, or successful candidates rather, from those women's only universities that the algorithm was relying upon to choose the successful candidates. So that's sort of one very famous example. I spoke about facial recognition earlier, and I think this statistic on the slide really shows you the issues with facial recognition technology. So 89 of 99 facial recognition algorithms failed to correctly identify non-Caucasian faces. And the reason for that is that when AI software engineers were putting together this technology, they were testing it far more on Caucasian people than non-Caucasian people. We've also seen a lot of recruitment agencies rely on algorithms to make sure that job alerts go to their preferred candidates. And in particular, this has come at the expense of equally, if not more qualified candidates from racial minority groups. And there's one statistic there that I've put on this slide that says that 40% of Black candidates were found to have received job alerts based on their identity rather than their qualifications. So that's another area where AI isn't actually operating in a non-discriminatory fashion, but targeting racial minority groups. If we could go to the next slide, please. Okay, so I think if there's sort of one thing that would be most important to remember today, it's this concept of the black box dilemma. So as I mentioned earlier, I think when AI was first introduced, a lot of HR professionals thought, perfect, hooray, all our recruitment decisions are now going to be free from human biases. And the issue that sort of employers have is that a lot of employers don't actually understand how the AI software and how the algorithm is operating to make decisions. So they might, and you see sort of the input arrow there, they will sort of put data into a particular algorithm, or the algorithm will operate in a particular way. But that is fairly invisible to the eyes of employers. So then when it produces a decision, employers and human beings really struggle to understand why that decision is being made. And the reason why that's really harmful is it could, for one, be producing discriminatory outcomes without the employer knowing. But where there are shortcomings, it's really difficult for an employer to address those shortcomings where they don't actually know what those shortcomings are. So AI doesn't have to be perfect. You can certainly use AI and know that it has its shortcomings, but it's really, really important as an employer to be aware of what those shortcomings are so you can take steps to mitigate against those shortcomings. But I think from the research that's been done, a lot of HR professionals and managers, etc., are actually unaware of how the algorithm works. And in fairness to them, it's because a lot of software providers aren't being that forthcoming with disclosing how their algorithm works, whether that be for commercial reasons or otherwise. So I think this is what's sort of landing employers in a lot of hot water. Their intentions are right. They're trying to use AI as a way of eliminating biases, but they're struggling to really determine whether or not actually AI is working in the way that they intended or hoped that it would. Next slide, please. Okay, so clearly there are benefits to using AI, and Heidi and I certainly aren't here today to say that AI should never be used at all. Clearly, where you're a big company and you're getting thousands and thousands of job applications, there are benefits to having AI sift through the candidates and hopefully put the most ideal candidates at the top of the pile. The issue is, and as we're going to explain today, there are legal risks with that approach, and Heidi will speak about that shortly in terms of the discrimination risks. But there are also reputational and financial risks with relying on AI and without knowing exactly how it works and without being able to confirm that it is operating in a non-discriminatory way. So you only, and I learned this sort of in doing research for this presentation, you only have to type into Google, employers, AI discrimination, and you'll get a number of companies appear on the first few pages of a Google search. So clearly that's not something that as an employer, you want your name to be associated with. There are also financial risks as well. So as we know in the discrimination space, there's no cap on the amount of compensation that a successful claimant can be awarded. So it can be really costly there. And as you can imagine, where there's one employee that has been treated in a discriminatory way by AI, there's most likely going to be a number of employees or candidates that also have been similarly treated in a discriminatory way as well. So that generally will lead to a large number of claims and can be incredibly costly to a business. This is also a particularly hot topic at the moment in the media, obviously with ChatGPT. It's a very topical conversation. So we've noticed in the last sort of 12 months, a lot of news agencies have really liked reporting on employers using AI in an unlawful or discriminatory way. And that is something, therefore, to be aware of when you are considering, or if you are using AI, that it's likely to receive some public attention where it's not used in a lawful fashion. Next slide, please. I believe I'm now
Yep.
handing back to Heidi.
Thank you, Charlie. All right, so thinking about the legal risk then, if we're using AI, the Equality Act 2010 is the law that sits behind what we're talking about today. And that act protects job applicants, it protects current employees and ex-employees, but also contract workers, agency workers, all from unlawful discrimination. It makes it unlawful to treat others less favourably because of a protected characteristic. Now, despite its title, the Equality Act doesn't actually require equal treatment from employees and applicants. Instead, it identifies particular characteristics that people have, and it offers particular protections where people are treated unfavourably as a consequence of those particular characteristics. So the question is whether AI could be discriminating in a way that it operates and the outcomes it generates for particular protected groups. This also raises questions around data protection, but we're not going to focus on that today. Clearly, AI systems in employment will be processing personal data if it's involved in making decisions about individual employees, and the AI is effectively looking at that individual in the work context. There are also protections within the UK GDPR where decisions about employees are automated. So employees are entitled to know about those decisions and for their data to be used fairly, lawfully, and transparently. Next slide, please. So, as the key risk here is discrimination, we're just going to very quickly go through what protected characteristics are covered by the Equality Act. Can I ask our attendees today to have a guess at what those protected characteristics are? And you can do that using the chat function. Throw in your thoughts on what characteristics are protected in the UK.
Feel free to use the chat facility. If you want to come off mute, if that's easier, just to answer the question, then feel free.
Any ideas, anyone? Age, thank you very much. That's definitely one of them. Gender, correct. Race, well done. Someone's doing brilliantly on this. And anyone else? Disability, thank you. Absolutely. Sexual orientation, correct. Any other ideas? Religion, that's right. And it's religion and belief. So it's not just religions, it can be other established beliefs. Any more? Trade union membership, that is protected. That is correct. You are protected for membership of a trade union, correct. So I'll flip on to the next slide, which gives us the answers just to pick up the extra ones. Have we got the slide there? Yes, yes. So just noting that pregnancy and maternity is a separate heading. Plus we have gender reassignment, marriage and civil partnership. And whilst it's not strictly a discrimination, part-time and fixed-term workers have protection as well. Okay, thanks very much for your contributions. To the next, oh no, sorry. Just to flag in the AI context, where these characteristics tend to come up, Charlie's already mentioned gender and race, and you can see how those issues are arising, but it could apply equally to any underrepresented group which isn't well represented in a historic data set. And for example, it could come up in disability, where, for example, body language is used by a bot in an interview context. For example, Charlie mentioned eye contact as one particular criteria for success, and we know that certain neurodivergent individuals perhaps with autism or ADHD may struggle with that body language element. And so again, you can see how these issues might arise, particularly around hidden disabilities. Obviously with things like someone being in a wheelchair, it's very obvious that that person is disabled, but most disabilities are actually hidden and not apparent to others, and therefore you could see how the issues could arise in AI. Next slide, please. So just very briefly how this applies in practice. So the most obvious type of discrimination is direct discrimination. So in other words, you have decided not to hire somebody because they are not white. That's in its crudest form. This could come up where, for example, the AI system has filtered out the non-white candidates for a role because the historic data set of successful candidates is comprising mainly white people, which has taught that system that white candidates are more successful. It gets a bit more difficult to spot with indirect discrimination. This is where a policy or a procedure or a requirement applies equally to everyone, but it is more difficult for people with a particular protected characteristic to comply with that policy or procedure or requirement. And this type of discrimination is possible to justify if it's objectively reasonable to do so. So the typical example that we use is, for example, a firefighter would need to be able to climb 10 flights of stairs, and that's a requirement of the role. This will obviously be more difficult for older people or disabled employees to comply with, but it's justified because that's a reasonable requirement of the job. So how could this apply to AI systems? Well, any part of the program which sets a requirement for success would fall within this category. So this has come up in the non-AI field where employers have required full-time working, for example, or unsocial shift hours, and that's been found to be discriminatory against those with childcare responsibilities. And Charlie is going to look at how this comes up in the AI context a bit later. Victimization and harassment are less relevant at the moment, I think, in the AI space, but who knows how things might develop as AI and particularly bots in the work context start to grow. We have seen that HR in large corporations are starting to use bots to answer straightforward HR questions that employees have about things like pay or holiday or benefits. And you could see that as the use of bots grow in communicating with employees, that it may end up sort of risking things being said to employees that they find unpleasant or harassing in the way that bot responds. So it's not there yet, I think, but possibly something to look out for the future. Next slide, please, and back to Charlie.
Thanks very much, Heidi. So as Heidi just explained to you, we've got largely the Equality Act that is regulating this space, and it's not really fit for the purpose of regulating AI. And I think, thankfully, the UK government recognises this fact, and Parliament at the moment has 2 working groups that have been set up to investigate how new laws can operate to regulate an employer's use of AI. So we've got the House of Commons Science and Technology Committee that's recently announced that it's going to review the regulations of AI in the UK, and it's called for any interested parties to make submissions on that. So if you really enjoy this presentation today, you can perhaps write to the House of Commons Science and Technology Committee after this. And there's also the UK All-Parliamentary Group on the Future of Work that recently actually issued a report that proposed draft legislation known as the Accountability for Algorithms Act. And relevantly, this act would impose a duty on corporates to disclose the way they're acting on algorithms in the employment space. Now that's a proposed law, it's not before Parliament just yet. So I still think we're some time away before we get to there. But it does show that the government and Parliament as well has this on its agenda. I think it's also interesting to note that other jurisdictions around the world, in fact, probably all jurisdictions, are having these discussions. In my home country of Australia, the exact same discussion is happening at the moment, where Australia doesn't really have laws that are fit for purpose, and there is this push to introduce new laws targeted at the regulation of AI. New York, interestingly, has introduced and passed a law that will come into effect in April this year. It was meant to be January this year, but it's been delayed slightly. And it does regulate the way that employers in New York can use AI when it's making employment-related decisions. And what this law will require corporates to do is that it will say, okay, you are allowed to use AI in your recruitment or employment-related decisions, but if you choose to go down that path, you need to conduct an audit every 12 months to satisfy yourself that the AI isn't operating in a discriminatory way. And further, you need to publish that audit on your company website. And in addition, you also need to notify all employees and all candidates that AI is being used to make decisions in relation to their employment. So I think probably at the moment, New York is the leader in this space. And given that a lot of AI software companies are based in the US and service employers in New York, I think that will have carry-on effects for the product that we see in the UK and elsewhere, because a software engineer isn't just creating a product that operates only in New York. They're creating a product that should hopefully operate in their eyes everywhere. The EU has also proposed legislation called the AI law, and that basically outlaws particular types of AI, including facial recognition technology in some ways. It's sort of still up for debate. And then it also lists high-risk AI technology, and it subjects that type of technology that's included on the list of high-risk software to certain obligations, and that includes at the moment CV sifting. So I think the UK has a couple of models that it can follow, both in New York and in the EU, and I would expect in the next couple of years that we'll see some form of draft bill go before UK Parliament. If we could go to the next slide, please. So I've already touched on the first example of where AI has landed employers in hot water. So the example that I spoke about at the beginning of this presentation about CV sifting technology discriminating against women was in fact done by Amazon. So that perhaps now sort of contextualizes the example slightly more. So Amazon has traditionally had a largely male workforce, and it was finding that when it introduced CV sifting technology, it was largely promoting male rather than female candidates. And I gave you the example earlier of its inquiries finding that the software was actually penalizing the word women in a candidate's CV. Amazon has since, unsurprisingly, stopped using that technology. IBM was a company that had developed its own facial recognition technology, and it has also since abandoned that technology because it found that it wasn't identifying non-white people in an accurate way. And Heidi will actually talk about an example shortly where another employer in the UK has encountered similar issues, or is alleged rather to be having these issues. And again, the research shows that the main reason for the facial recognition's failings is because software engineers are disproportionately using white faces when they're testing the technology and training it to recognize human faces rather than non-white faces. So in that respect, it really isn't any surprise, I think, that this technology is failing to operate in a non-discriminatory way. Notwithstanding these issues with facial recognition technology, we are seeing, as I mentioned at the beginning of the presentation, more and more employers using these sorts of technology to make sure that a particular worker is in fact personally performing their work, and that will normally be through an app. So if you need to sort of get a particular passcode in order to access your remote working system, it'll require you to upload a selfie at the beginning of the day. And what's been reported is that a number of non-Caucasian people are finding that the app is failing to recognize them. And that's where employers have landed in some hot water. And there's another example there of Microsoft having recently announced that it too is stopping its use of facial recognition technology because it's got some concerns that it's not correctly treating all people of all racial backgrounds in a non-discriminatory way. So that's quite a nice segue. Heidi, back to you for the next slide.
Thanks very much, Charlie. Okay, so yeah, let's look at some case studies from the UK. Well, actually, so far in the UK, there haven't been any judgments of the Employment Tribunal dealing with the use of AI for employers. But that doesn't mean that claims haven't been made. We're aware of several claims that have been raised by against employers that have been settled before reaching the final hearing. And the main reason for that is employers really don't want to be that test case and risk the publicity that comes along with being the first employer to have their methods tested. But also employers are frankly concerned about their ability to give that credible evidence about how the AI software is actually operating. And just remembering that employers would have to sit in a witness box and explain to a tribunal judge exactly what the decision-making process was. And then, of course, it may well be that there are genuine concerns about discriminatory conduct by these AI systems. And so clearly there's a sort of good reasons for settling claims that are raised. But it looks like we're going to get a judgment on this soon. We have a case involving Uber Eats, similar to the scenario that Charlie described. So a former driver for Uber Eats, Mr. Manjang, he's alleged racial harassment and discrimination on the basis that he was repeatedly asked to verify that he was actually personally undertaking his work using Uber's facial recognition technology. So in other words, at the beginning of his shift, he had to take a photo of himself and it wasn't recognizing him when he did that. Now, Uber Eats' policy was that if the system doesn't recognize your face, then you risk having your account terminated, which is exactly what happened to Mr. Manjang. Now, this case is being supported by the unions and also the Equality and Human Rights Commission, and they say that the AI system generates more inaccurate results for Black and minority ethnic workers, leaving them more vulnerable to losing their jobs with Uber. And in other words, it's indirectly discriminatory on the grounds of race. Now, we're not there yet. We have a final trial coming soon, and it's one to look out for to see how the Employment Tribunal approaches this issue in the court. Charlie, next slide.
Thanks very much, Heidi. And before I get to this next case study, in the excitement of talking about New York City's new laws, I actually skipped over who are the regulators in this space and what they're doing. So I will briefly return to that topic before we look at this particular case study. So in terms of what the regulators are saying about this, I think it's first important to be aware of who actually are the regulators of the way employers are using AI. So you've got the Information Commissioner's Office, that has just announced, or rather announced late last year, that it's investigating whether or not AI technology discriminates against racial minorities in the recruitment process. So they've already expressed a preliminary view that it very well may be discriminating against racial minority groups, and it's now undertaking a formal investigation as to whether or not that is happening. And I think the fact that we've got this Uber litigation in the background will only sort of provide a further sort of spotlight and impetus to the Information Commissioner to look into this matter more closely. Then we've also got the Equality and the Human Rights Commission that's recently issued new guidance on how public sector organisations can avoid discrimination when using AI. So I think from the fact that we've got the ICO that's announced that it's investigating this issue, and we've got the EHRC issuing guidance, it shows that it is on the agenda of regulators, and notwithstanding that there might be sort of laws that have failed to keep up with properly regulating this space, I think the regulators will certainly be doing what they can to ensure that employers operate in a non-discriminatory way where they do use AI. So I do apologise for skipping over that earlier.
Just to add, Charlie, to that, on the from the insurance perspective, of course, this is also very much of interest to the FCA, PRA, that's just concluded a consultation on the subject more broadly on AI in financial services, not particularly focused on employers, of course, but certainly we can expect those regulations also to capture any use of AI with regards to employees within the insurance space.
Thanks, Heidi. So going on now to this next case study. Now, this didn't happen in the United Kingdom. As Heidi mentioned, we're yet to actually have a judgment in this area in the UK. So we actually had to bring an example from Europe, in fact in Italy, where the Bologna Labour Court has recently handed down a judgment that found that Deliveroo committed an act of indirect discrimination. So I think firstly, before we talk about that judgment, it's important to be aware of the background facts. So riders for Deliveroo were basically given a score each week, and based on the particular score they were given, they were able to have essentially first access to sign up for the most competitive and commercially enticing shifts. This score was based on the frequency of a rider taking on deliveries within the first 15 minutes of commencing a delivery session, the frequency of a rider being available to perform deliveries between 8 p.m. and 10 p.m. on a Friday, and also the number of times a rider had to cancel a booked session at late notice, so within 24 hours. Now, a number of Deliveroo riders objected to this system and the system of getting a score. And it was an algorithm that determined this score. And what the court said when they were looking at this algorithm and determining whether or not indirect discrimination occurred was they said it's all well and good for Deliveroo to have this system in place, but this system has to be sophisticated enough to take into account the reasons why a particular rider might be cancelling a booked session at sort of short notice, or might be unable to participate in a delivery session between 8 p.m. and 10 p.m. on a Friday night. And the court spoke about childcare responsibilities and how that might affect a rider's ability to participate in a shift between 8 p.m. and 10 p.m. on a Friday, or also impact their ability to not have to cancel a shift at short notice. It also flagged riders with particular medical issues and said that the algorithm failed to consider these circumstances as well. And for that reason, they determined that the system was committing indirect discrimination. Importantly as well, though, the court commented that had Deliveroo been able to fully explain the way that the algorithm worked and perhaps be able to show that other factors are taken into account, that Deliveroo may have been able to successfully defend this claim. But Deliveroo chose not to give evidence on how the algorithm worked, and who knows why that might be. It might be, which is probably what I suspect, that a witness for Deliveroo just didn't have the knowledge and the expertise to properly be able to explain in a witness box where they're subjected to cross-examination exactly how the AI works. And I draw you back to the concept that I spoke about earlier, this black box dilemma, where employers know that they're using AI, they're hoping that it operates in a non-discriminatory way. They perhaps think that it does operate in a non-discriminatory way, but they're unable to explain and prove that. It was Deliveroo's failure to do that that meant that they were unable to discharge the reverse onus on them to show that their systems weren't operating in a non-discriminatory way. The other reason why they may have not wanted to disclose it would be for commercial reasons. So it may be that they were sort of subject to confidentiality obligations, or that the AI software provider refused to disclose all the details behind the algorithm. Who knows? But what we are seeing is that employers are more and more frequently settling these matters out of court. And we certainly suspect that's because they don't want or they don't have a witness that they can put in the witness box who can appropriately explain the way that the algorithm works in enough detail to persuade a judge that it is, on the balance of probabilities, not discriminating against a person or a group with a particular protected characteristic. Next slide, please.
Okay, so unless we've persuaded you all never to go anywhere near AI technology again in the future, I think this is more realistically about managing the risks here. And hopefully this session has given you a bit of knowledge that enables you to think about how we might go about doing that. So really the first step is about understanding, and so this is part of it. And certainly we've sort of delivered that message today, that you really need to know how, well, first of all, whether your business is using AI software, and if it is, how specifically it's being used, and how it's reaching its decisions, and ultimately whether that decision making is discriminatory. Now, obviously, that's not an easy task for lots of the reasons that we've just explained, particularly working out how the software actually operates behind the scenes. But as Charlie has explained, this is super important if we were to find ourselves in a tribunal situation. So therefore, getting that understanding, and then we would advise to undertake an audit to really understand and dig into what that means for the company. Now, obviously, this audit would benefit from being conducted on a legally privileged basis, so that any results, if they do indicate discriminatory practices, aren't disclosable to a claimant or to the tribunal. And it may well be necessary for you to engage with your AI software engineers to really properly understand how the technology was created and operates. Finally, there's a commercial risk management piece. Does your AI provider have anti-discriminatory tools built in to the software? What we've seen in the past is that some products sell this tool as an add-on. And certainly you should be ensuring that you've got that piece as standard. Also, looking at your AI software agreements for any indemnities in respect of discrimination claims, so that ideally the AI provider would be liable if the AI creates a discriminatory outcome, and the AI provider then bears the cost for that. Are there warranties in your AI software agreements that confirm that the software operates in a non-discriminatory way? So, ultimately, once you're armed with this information and you've focused on your risk management from a commercial perspective, then you're going to be in a much better position as a business to make informed decisions about your continued use of AI, the manner in which those systems are used, and if necessary, the level of human involvement that might be needed where automated decision-making processes are in play and need to be managed. So, next slide, please. Thank you. That wraps up our session, and hopefully now you have a good understanding of the learning objectives. And we thought we would just test you out quickly before we go, with a little quiz to see how you took in the session today. Charlie.
Thanks, Heidi. And what we'll do, and when we ask each question, we'll ask you, if you can, to type in the chat box, the meeting chat rather, what you think the answer is. So first question, which two jurisdictions have recently proposed or enacted new regulations targeting an employer's use of AI? And I emphasize the word proposed, so they don't have to be in law yet, but which two jurisdictions have recently proposed or enacted laws targeting an employer's use of AI? Perhaps actually, may I suggest just type in one jurisdiction so that we can get multiple answers. New York, correct. And so the laws in New York are coming into effect in April this year. And I see that Ian has correctly answered the EU. So again, those laws aren't as sort of progressed as the laws in New York, in that we don't have a date that they're to come into effect yet. It's still a draft proposal, but we are seeing those laws come into play. I think just on the New York piece, I think certainly if you are an employer that is using AI, I think it would certainly be sensible to look at employers in New York after April 2023 and look at the types of audits that they're publishing on their websites, because I think that will give some sort of guidance as to what you as an employer should be looking for when you conduct your own audits or seek the assistance of a law firm like Clyde & Co. So certainly one to look out for. Okay, I'll throw back to Heidi to ask the second question.
So which regulators in the UK have announced that an employer's use of AI has become a key regulatory focus? The ICO, absolutely. Yep. Can we remember the other one? It's always hard to remember it. It's hard to remember the name of this one, but it's the equality. Thank you for adding the insurance regulators. Thank you. Absolutely. They have taken a real interest in the broad issue of AI, which will, of course, filter through to the employee elements of that. The other one is Equality and Human Rights Commission. So very interested in this area, and as I mentioned, supporting the key UK case, which is just going through the tribunals now.
Thanks, Heidi. Okay, on to question 3. Okay, I'll be really, really disappointed if people can't answer this, because I think this is hopefully or probably the most important concept of the day. So what does the black box dilemma mean in the context of AI and employment law? Is it A, applications go missing in the black box of the web? Is it B, employers are unable to explain or understand the outcome produced by the AI algorithm? Or is it C, AI software provides a black box retaining information for employers to review? We've got B. Thank you. B, thank you, Lucy. Thank you, Ian.
Well done.
So as we saw in that Deliveroo case, Deliveroo was unable to lead evidence showing how the algorithm operated, and it was for that reason that it failed to discharge its duty to show that the algorithm was operating in a non-discriminatory way. So yeah, thank you all for your understanding of that concept. Back to Heidi.
Finally, which employer is currently in the tribunal in the UK regarding their use of AI? Yes, Uber Eats, exactly that. So we're all waiting with bated breath on the outcome of that one, and definitely one to keep an eye out for. So I'm conscious we have 5 minutes left of the session. Does anyone have any questions for myself or Charlie? Please do unmute yourself if you want to ask it that way, or please do put it into the meeting chat if you do have any questions for us.
Heidi, just while we're waiting for a couple of minutes, sorry, was someone just about to ask a question?
Yeah, I was. Hi, it's Connie.
Yep, go for
Chowdhury
it.
here. Thank you very much. Excellent session. And it's quite timely. I just watched something on Netflix called Coded Bias, which is very much in line with what you shared today. I think it's going to be a fascinating situation that develops. I was just wondering what you thought about, obviously in the UK, where we're appealing against the ECHR, and how you think that could impact the protected rights, and then therefore filter through to AI and some of the legislation and regulation that you discussed.
Could you ask that question again so I understand what you're asking
Yeah,
me?
sorry. So I think the UK government are discussing leaving the European Court of Human Rights,
Oh, I see.
and that would obviously potentially have an impact on some of the protected areas that you asked earlier around age, gender, sexual orientation, etc., etc. And just wondering how you think that could flow through and eventually impact some of the regulation that, if we were to leave the European Court of Human Rights, whether you think that those protected areas might come under threat and therefore would have a knock-on on some of the legislation and impact?
Yeah, it's a great question. Thank you. Well, what I would say is that the law around discrimination comes from the Equality Act, and that's a UK statute. Admittedly, it derives from European legislation, but it is very much implemented in the UK with UK protection. We haven't heard any real rumblings from government that there is an intention to change any of that law, despite our departure from the European Union and the issues that you talked about around human rights. So I think it probably won't impact unless, of course, the UK government decides to change the discrimination protection that we have in the Equality Act in the UK.
Great, thanks, Heidi. I think we've just about got time for one more question, so I'll just give you this one. Why do you think there haven't been any judgments in the UK determining whether an employer has lawfully used AI in the employment space?
Charlie, do you want to answer that one?
Happy to. I think it's simply because no employer at this stage wants to be sort of subject to the test case. So as Heidi mentioned, we don't have a judgment yet in the UK. We may have one soon with Uber, although my prediction would be that it's more likely than not going to settle, and I don't have any insider information. I'm purely guessing there. But I think, yeah, no employer at the moment wants to be subject to the test case. And in addition to that, if we do get a judgment, you can imagine it's going to get a lot of media attention for being the first sort of case in this space. And obviously no company or business wants that sort of negative publicity. So I think that's why we think these claims are being made, but they're being very quickly settled out of court rather than employers taking the risk of a adverse judgment. I think just finally, and I've sort of said this a couple of times, but I also think most employers probably don't have a witness that they think has the level of expertise to satisfy a tribunal that the algorithm is operating in a non-discriminatory way. Anything else, Heidi, to add to that?
Yep, no, that's perfect.
Okay.
I think that's right. I mean, we know these claims are being brought, and certainly there's some lawyers who are taking these cases on a pro bono basis to really push this issue forward. So I think it really is just a matter of time.
Great. Thanks very much, Heidi, and thank you, Charlie. I'll call it to a close there. It's 2:00, so right on time. So thanks so much, Heidi and Charlie, for your presentation today. I'm sure everyone will agree it's been really, really useful, fascinating, and very timely. So thanks also to all of you for joining us, and please don't forget to provide your feedback, which you'll see shortly, a form to complete, and do look out for forthcoming MGAA events. I do hope you all have a productive afternoon. Thanks again for joining us, and see you all soon.